Hello students, welcome to another episode of Recitals in Depth, where we are going to discuss the topics which have come under the section of Polity and Governance for the month of September 2024. The topics that we are going to learn today are falling under the broader themes of important key legislations, various governmental institutions, governmental policy and schemes, and certain constitutional provisions which were there in the news. Stay tuned. So the next topic for our discussion is Port Blair renamed as Sri Vijaya Puram. As we know that Port Blair holds a very historical significance for our country, and not only historical but very important from a geostrategic point of view, as Port Blair, being the capital of Andaman and Nicobar Islands, sits at the heart of Bay and Bengal. And India, in its recent diplomatic affairs and policies, has shown the inclination to dominate the Indian Ocean region, and Bay of Bengal forms a very important component of the Indian Ocean region. So now let us try to understand this core issue with respect to the renaming of the Port Blair to Sri Vijaya Puram. So now let's start with the discussion. So what we have to understand over here is that what are those political and administrative procedures which entails the renaming of a particular city or a village, whether be it in India or whether be it in the Union territories of India. Okay, so before we actually proceed ahead and discuss the various political norms associated with it, let's try to have a very brief background or a brief discussion with respect to the historical background of Andaman and Nicobar Islands. So as we know that Port Blair, the name of the capital of Andaman and Nicobar is Port Blair, and this Blair term comes from the person who actually did the survey of the Andaman and Nicobar Islands and who came across a natural harbor which was named after this particular person's name. So this particular person was named as Archibald Blair, and he was a lieutenant in East India Company. And in the year of 1778, he set on a sail from Calcutta to survey the islands of Andaman and Nicobar. And while doing the survey of the islands of Andaman and Nicobar, he came across a natural harbor. Natural harbor, in other terms, means ports. And since this person came across this natural harbor, he found this particular place and its strategic significance of that particular place. Earlier, this port was named after Lord Cornwallis, because during the viceroyship of Lord Cornwallis itself, this particular natural harbor was found, and later on it was renamed after the person who has found it, that is Blair or Archibald Blair. So this was a brief history with respect to the founding of the natural harbor called the Port Blair. However, in the year of 1789, the English East India Company established a penal colony over there. Penal colony means that it is a colony of the British East India Company on which it used to send certain convicts or persons who were troubling the East India Company as a punishment. However, they disbanded it in the year of 1826 because of prevalence of a lot of diseases, and they were not able to find it quite feasible to maintain that particular place. However, this penal colony was once again opened in the year of 1857 after the revolt of 1857, because English East India Company, they faced a lot of trouble after the revolt of 1857, and the entire revolt came as a shock to the administration of the English East India Company. So again they opened the penal colony in the Andaman and Nicobar Islands, and it sent the first batch of 200 prisoners to be sent over there. These are the prisoners who were the political prisoners or whom the British administration considered to be very notorious, who could threaten the establishment and the security and the peace of the English ruling of our country. And this cellular jail which was created over there, as it is one of the most important tourist or we should say dark tourism place over there. And 200 prisoners were sent to this cellular jail, which is also commonly known as in Hindi as Kala Pani. And many movies also have been made by the same name as well. So this was all about the brief history and its historical significance which this place holds in our India's freedom struggle as well. So now let us try to come to the core issue, which is what are the various procedures which are provided in our political customs with respect to naming of a particular city or renaming of a particular city. So now let's start with the first thing, that changing name of a city. Now, does the constitution say anything about changing of name of a particular city or a village? So the answer is absolutely no. The constitution is silent with respect to changing of name of a city or a village or a town. However, where majority of the students might get confused is the article number 3 of the constitution in the part 1, which says that it is the prerogative of the central government to change the name of a state. Name of a state. So constitution provides the power to the central government to change the name of a state and not the city. So this particular article, student might get confused and UPSC will play a very tricky question over here. So this thing we need to keep in our minds. However, constitution in the 7th schedule, as the 7th schedule contains the union list, state list and concurrent list, and under the state list, under entry 35, there is one entry by the name of land. And since state government is responsible for regulation of various affairs with respect to land, and ultimately the manifestation of land can be in various forms. It can be in the form of villages, it can be in the form of towns, or it can be manifested in the form of cities. And that is why constitutionally state governments are responsible for naming and renaming, because ultimately state government is responsible for regulating and legislating on the affairs related to land, which gets manifested in one of these 3 forms. And that is why state governments has the prerogative and the legislative competence to legislate on changing the name of particular towns, villages or cities. So this was the constitutional or the legal background or the legal foundation through which state governments try to change the name of the particular city. So in this respect, what various state governments have done is that they have created certain revenue codes or revenue legislations which empowers the state government to change the name of a particular city with the help of a notification, with the help of a simple notification which should be published in the Gazette. So as we already noted that land comes under the jurisdiction of the state government, and by legislating on similar front, various state governments have come up with various revenue codes through which state governments have been empowered to change the name by publishing a notification in the state gazette. However, what we need to note over here is that the central government have put a condition and a procedural guidelines with respect to procedure and conditions which the state governments has to follow before they can actually publish a notification in the gazette changing the name of a particular city. So what are these procedures and what are these conditions? So ultimately, central government in the year of 1953, it floated a circular to all states of our country, where it directed all the states to follow certain procedures and certain conditions for changing the name of a city. And state governments, if they are following this particular procedure and the conditions which are established by the central government, then by providing a notification in the official state gazette, state governments will be able to change the name of a particular city. So what we have to understand over here is that firstly we have to understand what is this procedure all about, and what are the conditions which has been imposed by the central government, which states government has to follow while naming or renaming of a particular place, whether be it a village or whether be it a town or a city. So now let's start with the first point, which is the procedure. So according to the circular which was published in the year of 1953, the procedure is quite simple. Firstly, the proposal to change the name of a city has to come from a MLA of that particular legislative assembly of that particular state. Now, as soon as this proposal is floated in the legislative assembly, there has to be a valid discussion on the intent and motivation behind changing the name. Thirdly, as soon as the discussion is done, the legislative assembly has to pass the resolution by simple majority, which makes it very easier for the legislative assembly to pass such a resolution. And as soon as this resolution is passed by simple majority, the state government then send this resolution to the Ministry of Home Affairs of the Union government, and this Ministry of Home Affairs then scrutinizes and examines the proposal which has been put forward by the state government. And in the process of this examination and scrutinizing of the proposal, the MHA consults with certain organizations of our country. For example, it consults Department of Post, it consults Department of Railways, it consults Intelligence Bureau as well. And apart from that, if that particular place has got certain diplomatic advantage or diplomatic significance as well, then the MHA also consults Ministry of External Affairs. And once this thing is done, then the MHA provides a no objection certificate to the state government, asking the state government that now the state government has received the NOC and state government will be in a position to issue the notification in the Gazette, in the state Gazette. And by the following of this procedure, state government will be able to change the name of any revenue place or any place, whether be it village, town or city. Now, since the procedure is very clear in front of you, what we have to understand are the conditionalities which were put forward by the central government through the circular of 1953. So what were the conditions? So the circular was very clear with respect to the conditions. The first one was, the circular noted that it is if there is no any special reason, if there is no special reason, then ultimately it is not desirable to change the name of a place, because ultimately it will come with a lot of administrative cost as well. Because once the name of the place is changed, all the revenue documents, all the governmental procedures, processes and mechanisms has to bring in the same name, and it will incur a lot of administrative cost as well. So ultimately, if there is no special reason behind the changing of the name, it is not desirable to change the name of the particular place. Second important point which it had mentioned was that in the process of changing the name, state government should take caution to avoid any kind of confusion which might appear if there is a similar kind of place or similar place with similar name. Place with similar name has to be avoided, so that again it will create a lot of administrative and governance confusion. Thirdly, it had proclaimed that any city which has got a lot of historical significance or historical connections, in that case the name should not be changed. And last important point, which is very important, and because the last point is so important that majority of the state governments actually provide this reasoning for changing the name of a city is that if any ancient city has fallen to decay or has lost its significance, the state government can reinstate the ancient name of that particular place. And this is the proper reasoning which variety of the state governments have used in changing the name of the various cities. For example, just like Port Blair, city of Allahabad was renamed as Prayagraj. So ultimately, state government triggered this particular reason number 4 for justifying this point 1, that is, if no special reason is there, it is not desirable to change the name of a particular city. And these are the various conditions which were imposed by the 1953 circular, which was floated by the MHA, Ministry of Home Affairs, as we had already previously noted. However, one last thing that we need to dwell on is that what is the reason which the government has chosen to change the name of Port Blair to Sri Vijayapuram? Because ultimately the vision behind this changing of the name was to throw away the yoke of colonial dependence which India had once faced. So ultimately India wanted to get rid of its colonial roots and to provide a unique Indian name to the place which holds a lot of historical and geopolitical significance for our own country. So this was all about this particular topic. Now let's come to the next topic, which is Standing Committee on Statistics. So this is again a very important topic. So now let's come to the context. So recently in September of 2024, what had happened is that the Ministry of Statistics and Program Implementation, in short MOSPI, and from now on I will be calling it MOSPI because it takes a lot of time. MOSPI, it dissolved a 14-member Standing Committee on Statistics, which was headed by the chief statistician of our country by the name of Pranab Sen. He is a very prominent figure in the Indian statistical ecosystem. And what MOSPI did is that it dissolved this 14-member Standing Committee on Statistics. So in this discussion, we are going to discuss why this particular Standing Committee was created at first place, what were its functions, and what are the possible reasons for which it got disbanded or dissolved, and what are the various structural elements or the institutional structure of MOSPI, that is Ministry of Statistics and Program Implementation, and we'll try to understand the various wings and divisions within the MOSPI. And after that, we will try to understand the various kind of problems or challenges which the MOSPI is facing with respect to coming up with various kind of statistical reports for the development and growth of our country. So now let's start with the first thing, which is what is this Standing Committee on Statistics and why it was created at first place. So ultimately earlier this Standing Committee on Statistics was constituted earlier in the year of 2019, and earlier it was known as the Standing Committee on Economic Statistics. However, this particular committee was enlarged in the year of 2023 and it was named as Standing Committee on Statistics, and it comprised of 14 members to actually have an oversight with respect to all the sample surveys or all the statistical surveys which were being conducted by the Ministry of Statistics and Program Implementation. So ultimately, what were the major functions which were to be performed by the Standing Committee on Statistics? So one of the most important function which was to be performed by the Standing Committee on Statistics was to review of survey framework and methodology for all the statistical surveys which were being considered or performed by the MOSPI, and to address issues related to survey subjects, results, methodology as and when raised by the MOSPI in front of this particular committee. The second important function which was performed by SCOS was advising on surveys methodologies, because it had been observed that various kind of surveys which was conducted by either National Sample Survey Organization or National Statistical Organization, that there were certain lacunae or inaccuracies with respect to the methodologies which were being deployed in the surveys. So it was the responsibility of SCOS to advise on improving the methodologies which were being deployed. The third is the ultimately finalization of various survey results. So as soon as various surveys are done, it will be the final responsibility of Standing Committee on Statistics to finalize the survey results and publish them. Fourth is to provide relevant guidance for various pilot surveys which were being taken place, so that various kind of pre-testing like procedures should be performed and all the data collection schedules should be scrutinized by the SCOS only. The fifth is providing guidance with respect to the exploration of administrative statistics. As our executive like functioning arm is the administration, in performance of various kind of service deliveries, the administration also generates a lot of statistical data, and how such data can be utilized in actually bolstering the data ecosystem of our country. So the SCOS has to provide certain guidance to the administrative departments also, so that the data which they are utilizing and holding can be utilized and can be applied to in creating better intelligence out of that particular data. Sixth is addressing data gaps. Now, since the methodologies and data collection methods has to be changed, SCOS has to provide guidance with respect to how to address the data gaps which is persisting in our India's statistical ecosystem. And lastly, to provide technical guidance to various central and state government agencies, so that whenever these agencies are involved in data collection or any kind of data processing activities, they all follow a very standardized mechanism, so that the data quality which is being captured remains uniform throughout the country. So this was the core of the core functions which were performed by the SCOS. However, the Ministry of Statistics and Program Implementation, it chose to disband this 14-member SCOS, and ultimately what it did is that MOSPI mailed the members of the Standing Committee on Statistics, and the mail had contained the reason about it, and what the government had provided the reason was that ultimately the government had created a steering committee on sample surveys in January 2024, and the functioning of this steering committee is overlapping with the functioning of Standing Committee on Statistics. So Government of India through Ministry of Statistics and Program Implementation, they felt that since there is a redundancy or overlapping of jurisdiction of the work which these two committees are performing, government chose to disband this particular thing. However, the commentators of India's political system and the commentators or various civil society activists, they are of the different view with respect to the government's reasoning. What had happened is that recently the Standing Committee on Statistics and its members had showed or presented their concerns over the delay in conducting census, and they were of the harsh view that why the government is not conducting the census which was to be conducted in the year of 2021, and even after passing of 4 years, the government is still not in the mood to conduct the census which forms the data foundation of any other surveys which are being conducted by MOSPI. And this was not well received by the Government of India, and ultimately Government of India chose to disband or dissolve the Standing Committee on Statistics because of political convenience or political reasons. So both the sides, both the government and the civil society activists have different point of views in this respect. So now let us try to understand the next part, which is the role of the new steering committee which the government had created in January 2024 itself. So what is the composition and tenure of it? The new steering committee consists of 17 members, increased from 14 which was there in the Standing Committee on Statistics, and 1 non-member secretary. 4 experts from the earlier disbanded SCOs were retained. Unlike SCOs, the new committee has more official members, leading to a shift in composition towards government representation. So ultimately this makes this committee more pro-government, or there is a government bias in this particular thing. And what are the terms of reference? So the terms of reference are similar to that of SCOS that we have already discussed over here. So these were the functions which are performed by SCOS, and the similar functions will be performed by Steering Committee on National Sample Surveys, which has been created by government in 2024. Now let us try to understand the institutional architecture of Ministry of Statistics and Program Implementation. So ultimately, the Ministry of Statistics and Program Implementation is definitely headed by a ministry just like any other ministry, and this ministry has two important wings. First is the wing of statistics, and second wing pertains to program implementation, as it is quite visible from the name itself, that is Ministry of Statistics and Program Implementation. That is why there are two wings. One is of statistics, second is of program implementation. Now the statistics wings, as you can see from here, this National Statistics Office is the statistics wing, and this NSO comprises of four important divisions, which is National Sample Survey, Central Statistical Office, Data Governance Office, and one additional secretary is there. Apart from that, one program implementation wing is there, which comprises of three major elements. One is 20-point program. Second is the project and infrastructure monitoring. And third is MP-LADS, that is Member of Parliament's Local Area Development Scheme. So these are the three major divisions within the wing of program implementation, and the statistics already comprises of National Sample Survey, which is very important. It basically publishes a lot of various important surveys which is important for better policy formulation for social development of our country. Second is the Central Statistics Office, which basically publishes your inflation data, etc. Thirdly is the Director General for Data Governance, etc., and one additional secretary is there. And apart from that, as you already noted, this MP-LADS forms under the program implementation, apart from infrastructure and project monitoring division, and also the third is 20-point program. So these are the major institutional structure of the Ministry of Statistics and Program Implementation. So now let's come to the important point, that what are the major challenges which are being faced by the Ministry of Statistics and Program Implementation to provide more granular, more frequent and accurate data in front of the people. So the first is the delays in census and surveys. So as we already know that census is conducted every 10 years, and the last census was conducted in 2011. And the next census was to be conducted in the year of 2021, naturally. Of course, this period was marked with severe COVID epidemic. However, even after passing of 4 years, and we are sitting in almost 2024, the government has not shown any concrete intent to conduct the census of our country. And this is actually deriding the integrity and credibility of the India's statistical framework. Since the government is not showing any kind of intent to conduct a survey, it is showing the government in a very bad light, and ultimately it is jeopardizing the credibility of India's statistical institutions and India's statistical overall framework. So the second point which we need to note over here are the data gaps and accuracy concerns. Now, it has been a very dominant tendency in whichever statistical reports the government has published in the previous 5 to 6 years, that there has been a lot of critique with respect to the quality of data which the government surveys has provided. To give you certain examples, so there was one periodic labor force survey which was published in the year of 2018. It was very strictly ran down by the government. That government itself did not agree to the findings of this particular data, because ultimately this periodic labor force survey had showed that India was facing unemployment of 45-year high. So because the government was not quite happy with the data. Government chose to run down this particular report and government did not accept it. Apart from it, there were also certain concerns, and the commentators of India's statistical system, many of the commentators, they showed that India's GDP numbers are also misleading. Apart from that, certain members of Prime Minister's Economic Advisory Council, which is headed by a very prominent economist and a very prominent academician, Mr. Bibek Debroy. So certain members of Prime Minister's Economic Advisory Council, they also noted that various kind of household surveys which were being conducted by the National Sample Survey Office, they were utilizing inaccurate data collection frameworks. That is, the method that these surveys were deploying to actually collect the data and the tools and technologies which are employed were not very technologically sound and inaccurate. Okay, so this was the core issue with respect to the accuracy concerns of the data which has been put forward by the MOSPI, and it again diminishes the majesty and the credibility of India's statistical institutions. The third is a lack of coordination. Now, since we know that India is a very populous country and ultimately various state governments are also considering their own surveys or conducting their own surveys, and ultimately central government is also conducting its own surveys, but there is a very lack of coordination between these two agencies. Why? Because there are lack of mechanisms and institutional networks which will facilitate the coordination between state government and central government so that they can provide a better convergence to the data that they both are trying to capture. And this diminishes the quality of data which is captured, and this diminishes the ultimately policy formulation which is created with the help of such captured data. The fourth important point which we need to note over here is the technology upgradation. Now, you will be surprised to know that majority of the surveys which are being published by the MOSPI are still utilizing very manual methods of data collection. Manual methods of data collection, which is, first of all, it's quite slow, and secondly, it is quite error prone. And the government has not been very proactive in upgrading the technologies which is involved in two levels. That is, first of all, there has to be more and more technology should be deployed in data collection. And secondly, whenever the data is collected, we need to gather intelligence out of this particular data. And more technology is required for data processing infrastructure. Data processing infrastructure. And Government of India is lacking with respect to deploying better technological resources in these two levels, which is again diminishing the credibility of statistical institutions. The fifth is, which is a very common problem in majority of our institutions of our country, which is the shortage of trained personals. Since India is a very large country and we need more frequent data, and to capture those frequent data, we need more trained personals, so that whenever a person is on the field trying to capture the data, he or she will be able to capture good quality data, which will ultimately result in better outcomes. And lastly, the informal sector. As we know that informal sector forms one of the largest chunk of our India's economy, and since informal sector does not have any formal data or databases, so our MOSPI finds it very difficult to actually ascertain or assume any kind of data prevalence with respect to this particular informal sector. So these are the prominent challenges which are being faced by the MOSPI, and which is hindering the performance of the MOSPI in coming out with more and more accurate and more frequent statistical reports, so that which can be used by the policymakers of our country to design better policies which will provide for better economic growth and development. So this was all for this particular topic. Now let's come to the next topic, which is legality of deception detection tests. So the key term we need to note over here is that deception detection test. And in normal language, we can understand deception as lie. So deception is nothing but lies. So ultimately, legality of lie detection test. So we will be using it interchangeably. That is deception detection test and lie detection test. And what do we actually mean by legality and all? So this is what we are going to discuss in this particular section. So what is the context? Why we are trying to learn this particular topic? So recently, as we already know that in Kolkata, in R.G. Kar Medical College, a very ghastly incident took place where a resident doctor was brutally raped and murdered. And followed that, the investigation was taken up by Central Bureau of Investigation. And this Central Bureau of Investigation is trying to conduct this deception detection test or lie detection test for the accused persons to get to know the reality or to get to know the truth or to identify which of the persons are saying lie. Okay, so that is the core context behind why we are trying to study or learn this particular topic. So before we go on and discuss the various kind of lie detection tests are there, firstly I'll try to give you a very brief introduction with respect to what are these deception detection tests or lie detection tests. So ultimately, any criminal justice system has a basic function is to provide justice to the people, and it will entail that whoever has done wrong should be punished and whoever is innocent should be spared. And ultimately, any criminal justice system has to interrogate to find the truth. So in the process of interrogation, the investigative agencies, which can be police, which can be any CBI or NIA, so these investigative agencies, they try to find the truth by deploying various kind of investigative techniques. So in the pursuit of finding the truth, they involve various kind of investigative techniques. And one of the most famous or rather infamous kind of investigative techniques are the deception detection tests, or deception is called lie, or which we will call as lie detection test. Now these deception detection tests are of three types, prominently are of three types. Firstly, it is called polygraph test. Second, narco-analysis. And thirdly, brain mapping. And what we will do in the course of the discussion of this particular topic is that we are going to discuss all these three methods, that is the polygraph analysis, narco analysis and the brain mapping test, and we will try to scrutinize and learn these three types of deception detection test with respect to what kind of methods they are deploying, what are its limitations and what are the criticisms to it. Okay, and what the Supreme Court has provided judgments with respect to these kind of tests. So now let's try to start with the first part, that is we are going to provide a comparative analysis with respect to these three tests. Now for every test, whether be it polygraphic test or narco analysis or brain mapping, we will try to understand or we will try to learn these things under these broader headings, that is what is it, what is the level of invasiveness, what is the control level of the subjects on which this particular deception detection test is being performed, and how much time it is required, or what are the major criticisms associated with it, or what are the major court rulings associated with that particular thing. So first of all, we'll start with the polygraph test. So in the polygraph test, the accused or the person on which the investigative agencies feel that this particular person has committed the crime. So what polygraph test does is that the investigative agencies try to observe certain physiological traits. And what are those physiological traits? Physiological traits are those traits of our body which are very physical in nature. For example, heart rate, for example, our blood pressure, for example, our surface skin conductivity, for example, our surface or body temperature. So what is done in this polygraph test is that the investigative agencies try to measure these critical physiological parameters like our heart rate, blood pressure, skin conductivity, and if we are sweating profusely, etc. whenever this particular person is asked questions about the crime. And similarly, in the narco analysis, what it is done is that here we are not trying to observe the physiological parameters. However, in this narco analysis, the accused person is provided or injected with a very important chemical which is known as the truth serum, or chemically it is called sodium pentanol, and which by the virtue of these chemicals, it lowers the inhibition of that particular person and reveals hidden information. And the investigative agencies, after injecting the person with sodium pentanol, with the effect of the sodium pentanol, the injected person lowers their inhibition, and the investigative agencies tries to investigate that particular person during that condition and tries to gather the truth which he or she might be hiding. The third important is brain mapping or P300 test. It is a neurological and neuropsychological test which measures the electrical activity in the brain of the accused when the subject is exposed to stimuli like images or sounds to determine the familiarity with the information. So to understand it with a very simple example, what we are doing or what we are trying to do in the brain mapping test is that we are trying to observe the electrical activity in the brain when that particular accused is shown certain information or told certain information with respect to the crime. So the core thesis behind this particular test is that the brain will react or brain will create different kind of electrical activity if we are showing certain kind of familiar information to the accused. And that is the core thesis or core assumption behind the functioning of this particular brain mapping test. However, now let's come to the second point about the level of invasiveness of these three particular techniques. So since the polygraph test is directly observing the physiological traits or the biological critical parameters which our body is showing, it is very less invasive and it monitors only external physiological signals. The narco analysis is quite invasive because it involves injecting the truth serum into the particular person, and again the brain mapping is non-invasive because ultimately we are observing the electrical activity of our brain with the help of certain electrical electrodes which are put on the head of the individual. The third is subject's control. Now under the polygraph test, the subject can consciously try to control physiological responses, however it is a bit difficult. In the case of narco analysis, since the person is in a very inebriated condition because of the sodium pentanol, it is not under the subject's control to like regulate their own behavior, and it is as good as that we are trying to interrogate a drunk person. The third is the subject may not be able to control brainwave recognition, making it harder to manipulate the test results. Now coming to the next parts is the time required. So the polygraph test requires 1 to 3 hours. Narco analysis, since we are trying to inject the accused person, so it takes several hours to conduct that particular test. And again the brain mapping test again takes only 1 to 2 hours. Now what are the criticisms associated with it? Now as we noted that the polygraph test is trying to observe the physiological critical parameters. However, there are various reports which shows that a person who is innocent and who is undergoing this polygraphic test, because of the stress, their physiological responses are not under their control, and ultimately it goes for a lot of false positives. And there is very less empirical evidences which suggest that because there is an heightened physiological responses like heightened heart rates or heightened blood pressure while a person is undergoing interrogation, it might be correlated, but that is not causal. So because of stress, a person can show enhanced or increased rate of physiological indicators. However, that does not conclude that particular person has committed the crime. Similarly, one of the major criticism of narco analysis is that after injecting a person with sodium pentanol, what it does to our cognitive systems and say neurological systems is that it slows us down and it throws up into a situation where it can be compared that we are trying to interrogate a person who is inebriated, that is a person who is drunk and who is not in senses. And the core of the core issue is that it lacks scientific reliability and memory distortion may lead to inaccurate information as well. And apart from that, it violates the individual's autonomy and privacy as well, since we investigative agencies are trying to inject a person with such kind of chemicals which have long lasting effects on their own cognitive abilities. With respect to the brain mapping, since it is limited in scope, it only indicates recognition of information and not actual involvement or intent. So it might be a possibility that our brain creates different kind of electrical activity when we are exposed to information which we had known prior. But that does not confirm that if we know the information, we have committed the crime also. So ultimately, this method also is not conclusive with respect to how we are able to ascertain the truth. And with respect to the Supreme Court rulings, we will try to understand the court rulings in the next section. So what we have to understand over here is that how the Supreme Court have and the courts of our country have addressed the entire issue. Now the watershed in the jurisdictional plane with respect to the deception detection test come in the year of 2010. Now before the year of 2010, various kind of high courts have provided judgments which were of the favor. For example, let's take a judgment of year 2006 by the name of Rojo versus Deputy Superintendent of Police 2006. This was a judgment which was provided by Kerala High Court. And in this particular judgment, the Kerala High Court was of the view that since the advent of the technologies or various kind of complex technologies have emerged, and because the technology has advanced so far, the level and complexity of crimes has also enhanced by multitudes. And to decipher the various kind of complexities of the crime, it is absolutely administratively feasible to use such kind of DDTs or deception detection tests, and these DDTs do not violate the fundamental rights of the individuals. So this was the stance of various high courts of our country who were dwelling with the issue of whether DDTs violated the fundamental rights of the individuals or not, or whether the DDT should be deployed or not by the investigative agencies. However, what had happened in the year of 2010 is that in the year of 2010 there was a Supreme Court judgment in the case of Selvi versus State of Karnataka in the year of 2010. And in this judgment, it was a very landmark judgment with respect to the jurisprudence with respect to DDTs. What the Supreme Court held is that whenever an investigative agency is going for DDT, it should only be done through the consent of the individual. And if the individual is not giving consent to perform such kind of DDTs, the investigative agencies will not be able to perform the DDTs over such individuals. And in providing such judgment, the Supreme Court noted two things. That in providing DDTs or in conducting or performing the DDTs, the investigative agencies, they were violating the fundamental rights of the citizens of our country in two ways. That it violated the Article 20 Clause 3, which is right against self-incrimination, that is person cannot be forced to be a witness or a party to its own case. And secondly, it went against the Article 21, that is the right to privacy. And Supreme Court held the view that no deception detection test can be performed on an individual without their own consent. And Supreme Court took the help of the guidelines which has been provided by the NHRC as well in the year of 2010. National Human Rights Commission had provided guidelines which the state governments or the investigative agencies had to follow with respect to performance of deception detection test for a particular individual. And what were these guidelines? So ultimately, first of all, consent has to be there. Second, consent of the individual. Secondly, option, whether an individual has to go for it or do not have to go for it. One option has to be there. Third is, if an individual provides for the consent to go for DDT, then this particular person has to be provided access to a lawyer. Fourth important point is that the police and the medical teams has to inform that particular individual about the various cognitive and physical effects of these tests on the individual. So these were the prominent NHRC guidelines or National Human Rights Commission guidelines which were published, and which the Supreme Court also mentioned that the state investigative agencies or any investigative agency for that matter has to follow before conducting any kind of deception detection test on any individual or any accused. However, the concern still lies with respect to the DDTs in our country. Now, despite the Supreme Court has given this judgment in the year of 2010, 14 years has passed by. However, Indian criminal scenario has seen more and more adherence to the performance of DDTs on the individuals. So this is a very alarming tendency that despite the 2010 judgment in the Selvi versus State of Karnataka, increased number of DDTs are performed by the investigative agencies, which shows the lack of investigative techniques with respect to our investigative agencies. And since these agencies are not able to come up with more and more advanced technologies in their investigative mechanisms, they ultimately resort to the DDTs to find out the truth. Second important point which we need to note over here is that there is a very famous advocate by the name of Rebecca John. What he had noted in one of his writings is that whenever an individual abjures from taking participation in any DDT, so if there is a refusal to participate in DDT, ultimately the defense lawyer or the prosecution lawyer, they try to deride their character in the court proceedings. Third point is also noted by various activists and experts that since the DDTs can only be performed with proper consent, and what activists are saying that ultimately this consent is coerced consent in the Indian police scenario, because ultimately police uses a lot of coercion and hardly anybody will consent to it unless they are coerced to do the DDTs or get involved in the DDTs. So these are the major issues which are still more pressing in the criminal justice system of our country with respect to the usage of DDTs. What we have to understand is the majority of the developed countries like USA, UK, Canada or European countries, they have moved away from such deception detection tests and they are more bent towards using more detailed DNA analysis, digital forensics and other advanced behavioral techniques in their own interrogative techniques. So what India can do is that India should also try to incorporate such best practices which the investigative agencies of other countries of the world are doing. so that ultimately this will provide a more autonomous and more dignified criminal justice system of our country. So this was all about this topic. Let's come to the next topic. Next topic for our discussion is how do emergency provisions under President rule impact center-state relations? So now let's come to understand the context behind this particular topic. So as you guys are aware that Manipur has been boiling with violence for almost last 1 year, and violence has been quite on and off because of the ethnic clashes and conflicts which are going on in that particular state. However, various political commentators and the persons who are observing the political functioning of our country and especially federalism, they were of the view that central government should have imposed president rule in the state of Manipur. However, the central government did not choose to do that or did not choose to go that particular way. So that was the core of the core context with respect to it. And the choice of the central government not to impose president rules can be very political as well, because ultimately both the central government and the state governments are run by the similar party or the same party, and that is why the central government chose, or as of now did not choose, to implement the president's rule in that particular state. So before we actually go on and discuss the various, say, the judicial pronouncement with respect to the president's rule or the state emergency, now let's start to get understanding of the core constitutional provisions which governs the president's rule in our country. So what are the emergency provisions in a way? So ultimately there are two articles which deal with this particular things, that is Article 355 and Article 356. What does the Article 355 says? So Article 355 says that it is the duty of the Union to protect the state governments against any external aggression and internal disturbances. This is the proper title of it. And what does the content say? That it shall be the duty of the Union to protect every state against external aggression and internal disturbances which Manipur is facing in a very severe way, and to ensure that the government of every state is carried on in accordance with the provisions of the constitution. That is, it is also the responsibility of the central government to ensure that the governance and the governance framework through which the state governance is run is based on the premise of the constitution of our country. And ultimately the following article is the Article 356, which is also commonly known as President's Rule. So what does this particular say? Provision in case of failure of constitutional machinery of a state. So if the President, on receipt of a report from Governor, is satisfied that a situation has arisen in the state government that it cannot be carried on in accordance with the provisions of the Constitution, then the President has the power to assume to himself all or any functions of the government of the state, or any of the powers vested or exercisable by the governor or any body or authority of the state. Second is to declare that the powers of the legislature of the state shall be exercisable by any authority of the parliament. And lastly, similar kind of situation which makes such incidental and consequential provisions to appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part operation of any provisions. So what does it mean is that ultimately Article 355 provides for the duty of the state government or the central government to protect the state government from any external and internal aggression, and to ensure that the governance in the state government is following according to the premise which has been set up by the Constitution. If the state government is following to do that, usually in our political functioning, it has been observed that the central government goes for the Article 356, that it imposes the president rule in that state if the president finds out that the governance in a particular state is not run according to the various provisions of the Constitution. So now let us try to understand, since we are clear with the constitutional provisions which governs the president rule in our country, now let's try to come and see how judiciary has tackled this particular issue. So as we know that there has been a lot of abuse of Article 356 in our Indian political scenario. And the first such instances, it goes way back to the year of 1951, and first president rule was established in the state of Punjab in the year of 1951, and so on and so forth. Every year governments had been imposing president rule on some of the states because of various political reasons, or if there is any kind of say aggression or external aggression or internal disturbances in that particular state. However, Supreme Court, it came up with a landslide or a landmark judgment in the year of 1994 by the name of S.R. Bommai judgment. S.R. Bommai judgment in the year of 1994, where it held that ultimately Article 356 has to be imposed as a last resort, and the central government should do everything in its own command and its power to make sure that the governance is run according to the Article 355 of the Constitution. That is, it is also the duty of the central government to ascertain that the governance is being run in the state government with the provisions of the Constitution, and to follow this. And it does not mean that in the pursuit of constitutional obligation, the central government should go for imposing the Article 356. And that is what it was dealt in the S.R. Bommai judgment as well. And another thing which it was noted in the S.R. Bommai judgment is that it prodded or encouraged the central government to exploit all avenues to ensure that the governance in the state government is running smoothly. And thirdly, it should go for floor test. If the central government is not sure, it should go for the floor test in the state government to ensure which party is governing the majority. And lastly, one of the important elements of the S.R. Bommai judgment was that it included the proclamation which was produced by the president imposing the president rule to judicial review. So if the Supreme Court or any High Court is satisfied that the president rule which has been imposed in that particular state is malified, then the Supreme Court can actually revoke such kind of proclamations. So this was all about the judiciary's stance on the abuse of Article 356. Now we also need to understand that what and how the interpretation of Article 355 has evolved throughout the years. Now, before we go on and discuss the evolution of the interpretation of Article 355, what we need to understand is two things. First of all, Article 355 stands for two things. Firstly, to protect state from any kind of external aggression, external or internal aggression. And secondly, it mandates the central government to ensure that the state governance is run according to the provisions of our Constitution. These are the twofold responsibilities of the central government which has been obligated by the Constitution of our country. Now, earlier, what had happened in the functioning of our constitutional regime is that the Article 355 was interpreted in a very narrow manner. That is, what this Article 355 was used as a justification by the central government to impose the Article 356 on any state government. That the reasoning of the central government was that since it is trying to protect, since Article 355, it has provided the power to the central government to protect the state government from any external or internal aggression, it is trying to impose Article 356. So earlier, the stance of various governments and courts were that ultimately the 355 became the logical ground to impose Article 356. However, over the years of functioning of our India's political system, the interpretation got more and more broadened, and people tried to realize the twofold objectives of Article 355. That is, first of all, to protect internal and external aggression, and secondly, to ensure at all costs that governance in the state government should go on with respect to the provisions of the Constitution, and to ensure that the governance in a state government is going on according to the Constitution. The central government should deploy all mechanisms at their helm whether be it constitutional mechanisms or whether be it legal mechanisms, to ensure that all the governance in the state government is following or is based on the constitutional premise. And even after deploying such things, and if after exploiting all the avenues which are there with the central government, if it is not being followed, then only the central government can go for imposition of precedent rule by invoking Article 356. Various kind of judgments has also tried to broaden the scope of interpretation of Article 355 with respect to the constitution of our country. One of the most important thing is Naga people's movement. Naga people movement of human right versus Union of India in the year of 1998, and it provided that the central government can actually deploy armed special power forces, can deploy armed force AFSPA, that is for army, in the pursuit of Article 355, which is to protect the state from any armed external or internal aggression. And in the pursuit of protecting the state, the central government was implementing the AFSPA legislation. And similar case was also noted in Sarabnand Sonowal versus State of Assam in the year of 2005. And such kind of judgments, they actually broadened the interpretation of Article 355 with respect to the application before Article 356. And what are the various committees which have suggested with respect to the application of Article 356? So primarily there are three major committees. One is Sarkariya Committee. Second is the National Commission to Review the Working of Constitution, or also known as Venkatachalaya Committee. And thirdly is the Punchi Commission. Punchi Commission, which was in the year of 2010. All these three committees were recommending suggestions on the similar lines, that is to promote more and more cooperative federalism. And what does it mean by imposing the cooperative federalism? That in the pursuit of following Article 355 or the goals which has been provided to the central government by 355, the central government must try to exploit all avenues to make sure that the state government is run in a more democratic manner without interfering in the autonomous functioning of the state government. The second point which it noted is that it tried or prodded the central government to use the interstate councils and zonal councils before imposing Article 356. And thirdly, it also suggested and recommended that Article 356 or the precedent rule should be the last resort of the central government. And fourthly, it also provided for a very neutral stance which has to be played by the governor in such kind of cases, where governor has to be playing a very apolitical and neutral and non-partisan role, so that he should be able to provide a very objective, fair and verifiable report to the president of our country, which should be also publicly accessible to everyone, so that we should be able to assess the neutral role which has been played by the governor. So this was all about this particular topic. Now let's come to the next topic, which is National Consumer Disputes Redressal Commission. So now let's try to come to the core of the core issue. So recently, what has happened? What is the context of it? So recently, the National National Consumer Dispute Redressal Commission, NCDRC for short, it has denied the plea by the State Bank of India to transfer its case in the consumer case out of Tamil Nadu. Now, to understand what is this National Consumer Disputes Redressal Commission, what are its functions, what are its compositions, etc., and what are the various important institutional architecture to promote the rights of the consumers, we need to understand the core legislation behind it, which is the Consumer Protection Act of 2019. Now, this Consumer Protection Act of 2019 is a second act which was enacted by the government of our country. The first act was Consumer Protection Act of 1986. Now, since this act got very obsolete and old, and with the advent of a lot of technologies and emerging domains like e-commerce and say misleading advertisements, the government of India felt the need to come up with a new legislation, and they repealed the old act of Consumer Protection Act of 1986 with a new act of Consumer Protection Act of 2019. And what does this Consumer Protection Act of 2019 stands for? It is a very benevolent social legislation which provides for two things. First of all, it provides for the rights of the customers, and secondly, it provides for the institutional architecture for promotion and protection of rights of the customers. Okay. So these are the various important two elements which has been dealt by this particular legislation. So now we will try to start first with the first point, which is it has provided a very explicit rights of the customers. So rights has also been provided to the citizens of our country through Consumer Protection Act of 2019. And it has provided 6 such rights. And what are those rights? First of all, right to safety. Second, right to be informed. Third, right to choose. Fourth, right to seek redressal. Fifth, right to consumer awareness. And sixth, right to be heard. So these are the prominent 6 rights which has been provided by this particular legislation. However, what we also need to understand is the second important element, that is, what is that institutional architecture which has been established by this particular act, and under this institutional architecture, one of that institution is the National Consumer Disputes Redressal Commission, which is the core of this particular topic. So now we will try to elaborate on this particular part, which is the institutional architecture which has been established by the Consumer Protection Act. So to promote and protect the safety of the rights of the consumers and or the customers, and secondly, to provide for a very speedy, effective and inexpensive redressal of the grievances of the customers, what this CPA 19 has done, or the Consumer Protection Act of 2019 has done, it has provided for a 3-tier architecture of institutions. 3-tier architecture of institutions, which starts from the district level and it goes on till the state level, national level. So it starts with district, state and national. And at the district level, it has District Consumer Disputes Redressal Commission. In the state, it has State Consumer Disputes Redressal Commission. And in the nation, it has what we want to study is the National Consumer Disputes Redressal Commission. Now what we also need to understand over here is the jurisdiction of such things. Now, jurisdiction is very clear. Jurisdiction is of two types, that is the national NCDRC will function at the national level. So there is only one NCDRC which is located at Delhi. Almost every state and union territories have their own state consumer dispute redressal commissions. So their jurisdiction will be geographically, it will be state, and similarly districts, their jurisdiction will be in the domain of their district itself. And with respect to the pecuniary jurisdiction, pecuniary means the amount of money which is involved in the dispute they can handle. So ultimately district commissions are allowed under the act for the pecuniary jurisdiction of smaller than 1 crore. State are allowed from 1 to 10 crores and national commissions are allowed for more than 10 crores. So these are the important pecuniary jurisdiction that we need to keep in our minds. And if there is any, if the consumer is not satisfied with the dispute redressal commission at one level, then he or she might try to appeal in the next level. So if a person is not satisfied with the judgment which has been provided at the district consumer dispute redressal commission, they can appeal to the state commission. And if a person is not happy with the judgment of the state commission, they can appeal to the national commission. And what will happen if the person is not satisfied with the judgment which has been provided by NCDRC? Then the person can appeal to the Supreme Court of our country, however, within 30 days of the judgment which has been provided by the NCDRC. So this was a very, very important element with respect to the functioning and the institutional architecture which has been present in the country, so as to provide a very speedy, fair and inexpensive trial so that consumer rights are protected. Now, one more important thing that we need to note over here is that who can actually complain to these NCDRCs? Who can complain? So naturally one customer can complain. Voluntary associations of the customers can complain. In case of death of any particular individual, their legal heirs can complain. And fourth point, both the central government and state government, if they are also a customers, they can also complain to the NCDRCs. So this was all about the various provisions of the Consumer Protection Act of 2019, the rights associated with the customers which has been provided by the act, and the institutional architecture which has been set up under this particular act. So this was all about this particular topic. Now let's come to the last topic for our discussion is Pradhan Mantri Awas Yojana-Gramin. So now let's try to understand the context for which we are trying to understand this particular topic. So the context is recently in the implementation of the Pradhan Mantri Awas Yojana-Gramin, there is a criterion by the name of automatic exclusion. Automatic exclusion. And this automatic exclusion means that it will exclude certain category of persons from the list of beneficiaries, or the persons who will be eligible to derive benefits from the implementation of this particular scheme. So recently the government of India has tweaked these automatic exclusion criterions in certain ways, which we are going to discuss in this particular section. So before we go on and discuss the various aims and objectives and the features of the Pradhan Mantri Awas Yojana, firstly let's try to have a very brief overview of the history of public housing programs in our country. So the history, with respect to the history of public housing programs in our country, similar kind of interventions started just after 1947, when the government of India tried to rehabilitate refugees. And for the rehabilitation of the refugees and to provide them with decent living conditions, government of India had provided them with houses. And ultimately this continued for a lot of years, and one very important scheme which you should know from the examination point of view is the Indira Awas Yojana, which was launched as a very separate scheme in the year of 1996, 1st of June, and which catered to the housing needs of below poverty line people. And then in the year of 2016, the government was very sensitive and kind enough to go for a very important goal, that is housing for all by year of 2024. And in the pursuit of following this goal of housing for all by the year of 2024, Government of India launched this program by the name of Pradhan Mantri Awas Yojana-Gramin. So this was a brief overview of the history of public housing programs in our country. Now let's try to understand what are the core aims and objectives of the Pradhan Mantri Awas Yojana-Gramin. So ultimately we know that the broader goal of the Government of India is to provide housing for all by 2024, and to perform this or to meet this goal, Government of India came up with Pradhan Mantri Awas Yojana-Gramin. And the core aim and objective of the Pradhan Mantri Awas Yojana-Gramin is to provide quality house, quality pakka houses. Pakka houses means the houses which are made of brick and mortar, okay, to those houseless households. Houseless households, the households which are not having any houses, and you will be, it is a very unfortunate view, or a very unfortunate view, that many of the people or households, they live under the bypasses, they live under the flyovers, etc., or they sleep on the pavements or say sidewalks, etc. And to those people who live in kacha houses, kacha houses means the houses which are made of muds, having 1, 2 or 3 rooms. So this was the core aim and objective. And second was that in pursuit of providing pakka houses to these individuals, financial assistance will be provided by the central government to such eligible beneficiaries, so that these people will be able to make their own qualitative house, and ultimately which will lead to a more dignified living conditions, which is one of the most important objectives of our Indian state also, which is also enshrined in the preamble of our constitution. So this is the core of the core goal or the aims and objectives of the Pradhan Mantri Awas Yojana-Gramin. However, now let's try to come to the features of this particular program through which the government is trying to provide pakka houses to the eligible beneficiaries of our country. So the first of all is that the minimum unit size of that particular house, the Government of India is catering to almost 25 meters square. Secondly, the unit assistance, that is what amount of money is the Government of India is paying to the eligible beneficiaries. So ultimately 2 categories are here. For the plains, government is providing 1.2 lakh rupees per unit. That is, for every house, government is providing rupees 1.2 lakh. And for the northeastern states and the hilly regions, government is providing rupees 1.3 lakh per unit to the eligible beneficiaries. Who are those eligible beneficiaries? How do the government identify those eligible beneficiaries? That is the core issue of this particular topic, which we will discuss in the coming section. However, before we do that, we should try to have a good idea with respect to the various features of the program. The third is the sharing of the cost. So the cost is shared between center and state in various ratios. So again, in the plains, it is being shared in the ratio of 60:40. In the hilly regions or in the northeast states, center and state are having a coordination of 90:10 ratio, and in the UTs, it is of course 100% by the central government. Now, with respect to, there is another very important feature of this particular scheme which is the convergence with other social developmental schemes. For example, any say Pradhan Mantri Awas Yojana will help the individuals or beneficiaries to erect or construct a house. However, that house will convert into a home only if it has got very beneficial amenities. For example, drinking water, for example, electricity, or for example, LPG connections. So what it provides, that it should be converged with other social sector schemes like NCDRC or Swachh Bharat Mission for the construction of toilets, with the Pahal scheme for LPG connection, for Deen Dayal Upadhyay Gram Jyoti Yojana, for rural electrification. So every household which is a beneficiary under the Pradhan Mantri Awas Yojana-Gramin will also be getting more and more convergence with respect to the other schemes which the government of India is already implementing, however, in the other sectors. So ultimately, the particular beneficiary do not has to go in a very silos manner, but he will be provided services of such schemes in a very converged manner. Now, the fifth point is unskilled labor, which means that the beneficiaries will be provided unskilled labor of 90 to 95 days under the NCDRC. Sixth point is National Technical Support Agency. This is again a very important point which we need to note over here, is that under the Pradhan Mantri Awas Yojana-Gramin, a National Technical Support Agency has been created to actually provide support to beneficiaries and the other various stakeholders like who are taking care of the construction of the units with respect to what kind of building material to use. Second, what kind of designs to be deployed so that it has to be more disaster resilient. Thirdly, how to make the buildings very green in their own component and to come up with more and more norms so that more and more states should go for adoption of such green building techniques. Green building are those buildings which are very sustainable in their overall approach. And ultimately, last thing is the rural mason training. Now, ultimately, as you must have seen certain construction activities which goes on near our households itself or in our neighborhood, that it requires a lot of masons. Masons are such skilled craftsmen who will join bricks layer by layer and will provide a very good construction quality. And we will be able to attain good quality of construction only if we are having masons who are equally skilled. And to provide a large number of masons in availability in the rural areas, the Pradhan Mantri Awas Yojana has come up with rural mason training, which is getting implemented with the assistance of National Skill Development Corporation, which forms under the Ministry of Skill Development and Entrepreneurship, so that rural areas have more and more masons, so that these masons will be able to construct more and more houses. Because ultimately, to achieve the goal of housing for all by 2024, it is estimated by various reports that almost 2.95 crore units of houses are required to be constructed. And to construct such a large number of houses, we need a large number of rural masonry as well. And to help these shortages in the supply of rural masonry, this rural mason training, which is actually implemented by National Skill Development Corporation, is going to play a very monumental role. Now let us try to come and understand one of the core issues that we have to understand. That is, how does the government of India select the beneficiaries for the Pradhan Mantri Awas Yojana-Gramin? Now, as we already noted that to provide for housing for all, we need to construct almost 2.59 crore houses. And one of the primary and most critical problem which the government faces in implementing any social sector scheme is to identify the beneficiaries. So identification of beneficiaries becomes one of the most critical leg in the implementation and finally the success of a particular social development scheme. Because ultimately, if we will over include beneficiaries, then it will lead to dilution of the public funds, and the public funds will flow to even those people who do not deserve it. And if we'll try to exclude people, then ultimately we will increase more and more exclusion, and the public fund which should have gone to the more needy of the persons will not go. And ultimately the success rate of any social developmental scheme depends on how beautifully the identification parameters has been designed. So in the case of Pradhan Mantri Awas Yojana-Gramin, the central government is trying to identify the beneficiaries using 3 layers. Firstly, it is trying to take care of the household deprivation parameters. Household deprivation parameters of the socio-economic caste census of 2011. Apart from that, it is also taking care of the help of Awas survey. Awas Plus survey, which was done in the year of 2018. And once these two, out of these 2 lists, people are identified, then at the 3rd level, the Gram Sabha of that particular beneficiary has to ascertain or has to verify that this particular person is eligible to receive benefits under the Pradhan Mantri Awas Yojana. And through following these 3-step processes, the government is trying to include only those people who actually deserve the benefits which is coming out of the Pradhan Mantri Awas Yojana, so that the funds which the government of India is mobilizing goes to the most backwardly and needy person of all, and it should try to minimize the leakages or the corruption which might crop up in the entire implementation value chain. So these 3 mechanisms are very important. Apart from it, there are certain automatic inclusion as well. What do we mean by automatic inclusion? So apart from the household deprivation parameters that we already witnessed in SECC or Socioeconomic Caste Census and the Awas Plus survey, there are certain criteria through which if a person is following under this one of these criteria, they will definitely automatically they will get included in the list of beneficiaries. Similarly, there is one automatic exclusion parameters as well, which we saw in the context of discussion of this particular topic, that if a particular person is falling under one of the criterion, they will be removed out of the beneficiary list of the Pradhan Mantri Awas Yojana-Gramin. So what is the criteria for automatic inclusion? If any household is living without any shelter, if any destitute person is there, or manual scavengers are there, or if there is any primitive tribal groups and legally released bonded laborers, these 5 criterion people are automatically included in the beneficiary list of Pradhan Mantri Awas Yojana. Now let's try to come to understand the automatic exclusion process. So ultimately, exclusion happens in 2 levels. First is exclusion of pakka houses. So any person having pakka houses, that is houses made of bricks and mortar, they will be excluded from becoming a beneficiary of Pradhan Mantri Awas Yojana-Gramin. And secondly, that we had to discuss is the automatic exclusion. So if the government of India had provided these 13 conditions, and if a person is from the remaining set of households, all households fulfilling, even if any one of the 13 parameters listed below are automatically excluded. So what do we mean? That if any particular person or any household, if he or she or if they are having any one of the 13 conditions, if it is fulfilled, then they will be excluded from the beneficiary list of Pradhan Mantri Awas Yojana-Gramin. However, what we had to note over here is that recently government had tweaked or changed the automatic exclusion parameters. So what were those exclusion parameters which government had removed, so that ultimately it is leading to exclusion? So what government did is that it removed this motorized 2-wheeler condition from this particular thing and retained this 3 and 4-wheeler. Apart from it, it also removed this thing, owning a refrigerator and owning a landline phone. So these 3 conditions, apart from it, this mechanized, these 3 conditions has been removed from the automatic exclusion criterions which has been published by the Pradhan Mantri Awas Yojana-Gramin. And why did the government reduce this automatic exclusion criterions? Because by owning a motorized two-wheeler or owning a refrigerator and own landline phone, it does not mean that the particular person does not deserve to be involved in the beneficiary list of Pradhan Mantri Awas Yojana-Gramin. So government, to increase more and more penetration of the public funds and to make sure that these public funds are released to the most of the needy persons, they relaxed these conditions and removed these 3 conditions from the 13 conditions which were earlier imposed. So this was all about this month's edition of Recitals in Depth for Polity and Governance. I hope it will be a very informative session for you. Stay tuned for the next month. See you.